G'day folks, Mad Aussie here and welcome to the Aussie Report. In this episode we're going to take a look at a bit of a disturbing video. This one is about child abduction and how the system separates children from their family and how it all goes wrong. This is it's from a YouTube channel called Child Abduction. They've stated this first one as case 001. They have some previous videos along the lines of all this child abduction in there, but this is their first case video, so I'm sort of hoping that they produce more. It is a hard listen, but it's the kind of thing that we need to know and understand so that we can be outraged enough to change it, because the system is corrupt, and this video goes through how corrupt it is. The video itself goes for 25 minutes, but I'm just going to play about 5 minutes for you to give you an idea. I don't want to take all their content. I'd then like you guys to go over to the Child Abduction channel on YouTube, which will be linked in the description below, and give them a like and a share and watch the full video there to really understand what's happening in this story, because it's just wrong. It really is wrong. So jumping over there now, this is it, and yeah, I'll just jump straight into it.
Ladies and gentlemen, thank you for being part of the People's Commission Case 001 SA. On 27 September 1997, Nelson Mandela said, "The true character of a society is revealed in how it treats its children." So what is the purpose of the People's Commission? Where justice is unobtainable for children through the mechanisms offered by government and the courts, then the people have a duty as a society to try assist those children. When it has become clear that many children are denied natural justice by the children's and youth courts in Australia and are subjected to a life of cruel punishment and the deprivation of humanity, then the very core of our society is in question. It has become clear that all across Australia, child protection departments and the children's courts are acting against children, separating children from a parent or parents on hearsay and finger pointing. Could this be considered trafficking, as it appears that the department and courts are facilitating the demands for an out-of-home care multi-billion-dollar industry? And when those parents ask for help from their government ministers, department heads, corruption and judicial commissioners and governors, no help is forthcoming. No one wants to interfere with the business that is the state condoning child removals on a mass scale. Of course, I will be respectful of the secrecy laws when discussing this and other cases, but you can be assured that these cases are shrouded in secrecy, not for the benefit of the children, but for the benefit of those that have committed crimes against children. So let me get to the first case, 001. There are thousands and thousands of pages relating to the facts of this case, but the department's court strategy is to drown the case with so much paperwork that the court seems to refer to the weight of the paper and not to the facts. The department also has the modus operandi of throwing as much mud as possible, hoping that some sticks to validate their claim of ownership over the child. But in this instance, the facts are very clear. Sexual abuse and exploitation had been substantiated in 2016. Early that year, the child told her grandmother that her father and female associate had taken her to a house and taken naked photographs of her. The grandmother made the notification of sexual abuse, and the department, formerly Families SA, removed the father from the home. The child was interviewed for 1 hour by a CPS investigator, and the detailed narrative that was provided by the child and how she described it and in what context the CPS investigator said was much too reliable. As part of the Families SA and CPS investigation, and because the father had accused the mother of being delusional, she was assessed by forensic psychiatrist Dr. JB. His report cleared her of all mental health issues. After the investigation of several months, Families SA and CPS substantiated sexual abuse and exploitation, and that the father had emotionally abused the mother. Their findings were detailed in letters to both father and mother in mid-2016. On receiving the substantiated letter, the father applied to the family court for sole custody. As I've previously published, this is a trick often used to stop further investigations by agencies and to prevent prosecution. However, everyone at this time, including the department and CPS, was supportive of both mother and child, especially in her gaining custody. The child was safe in her hands. I would like to note here that Dr. JB subsequently cleared the mother a second time for the family court trial, plus clearing her of any coaching. But now the crucial part of the case. It was late in 2017, mid-family court trial, and just after the child had turned 8, that an officer, Officer CT, conducted a police interview with the child. In this interview, that lasted well over an hour, the child disclosed in detail sexual abuse, and I will not detail these. It's suffice to say that they were extreme and were forms of child sexual abuse, assault, versions of rape, and death threats. After the interview, the officer told the mother that the child had passed the truth test, told her some heavy stuff, but there was nothing to go on. From this day on, the officer's actions would forever harm the child. After the interview, the officer entered crucial fabrications in her report, writing things like, the child forgot what she was supposed to say, etc. But the child never said this. It was a blatant lie. It is crucial to understanding this case that Officer CT did not report those late 2017 disclosures to CARL, which is the Child Abuse Report Line. Reporting of a suspicion that a child or young person may be at risk is a requirement by law, especially as sexual abuse and sexual exploitation had been previously substantiated. And this is under Section 31 of the Children's and Young People Safety Act, that if a person suspects on reasonable grounds, they must report that suspicion as soon as it is reasonably practical. And under Section 30, as a police officer, she was obliged to keep that child safe from harm. These new disclosures, along with the past substantiation, would have elevated this to a criminal matter to further bolster CPS and the department's established view that the father was the offender and the mother was the protector, and that the child was safe in the mother's care. The forensic evidence of blood-stained underwear, etc., that had been handed in would have been then tested at CIB.
Okay, so this does get, quite traumatic, but as all things that I do post, I believe that we need to know about these things, as I say, so that we can be outraged enough to do something about it. We can't ignore it and turn a blind eye to what's happening to the children in this country, done by the system itself that's put in place to protect them. So yeah, like, share, subscribe, all that good stuff, and I'll catch you guys on the next episode.
Try to play, but you're never gonna beat me. Look the other way, what I'm doing ain't easy. Bloody hands stained from the people who deceive me. Muddy hands break through the chains, go free me.